move on to say that you can pay them based on a contract from a contractor, you can pay them based on an inspection of completion, or you can pay those code issues as incurred by the insured. So have a good relationship with your adjuster. Ask them up front, when can I expect to get paid for this? But it's not required. So it's not bad faith they don't pay it if it wasn't there up front. Now, it is bad faith if they're not complying with the law and the code. But you've got to be careful to make sure you have code coverage. I'm shocked at some of these bigger carriers now that are not offering these code coverages. In fact, they'll name their policies deluxe, okay, XYZ deluxe insurance policy, but it doesn't cover the codes. It's really disgusting. It's to me, it's not good. Okay, if we have to prove it, can we charge for an extra trip or photography charges? You're never going to get paid it, and you're never going to find a lawyer or Rob to file a lawsuit over a tripping charge or a photography charge. Okay, yeah, you're just not going to find anybody to take that case over a couple $100, and they know that. So unfortunately, yeah, I mean, if you incur it and it's part of a cost to your customer, the insurance company should indemnify you if it's reasonable. I think it's reason. The truth is they often make contractors do a lot of extra work. I represent contractors and clients that have to provide photographs and document the loss, and they're almost acting as a public adjuster, right, Rob? I mean, what Kevin Burpee does for you and Dwayne, those guys will go out there and document the losses very effectively, but they're getting paid as a public adjuster. That's part of their job. A contractor, they're almost requiring you to prove up your loss for the policyholder before you get paid. Now, that's something you can work out with your client, I guess. That's going to be their position, is that, well, they have the obligation to prove up their damages, and you got to prove that they actually incurred that. Let's see. I got a lot of stuff here. Staff adjusters are the hardest ones to deal with. Levi, that's just claim by claim. You're right, sometimes they are, but sometimes I think the hardest ones to deal with are those pilot adjusters or the CAT adjusters that don't have any experience. You've got somebody who's never hung drywall, laid tile, put a roof on, and they're arguing with you over overhead and profit. They're arguing with you over charges. They just don't have any construction experience. No, Chris, it's not a requirement to have ordinance and law coverage in Illinois or any other state. It's an optional coverage, at least to the best of my knowledge. Richard, are they allowed? This is something I see often. Are they allowed? This is how petty the insurance companies are. Are they allowed to deduct the felt for that they covered after they put it on the scope when they add the ice to the claim? I think what Richard is saying, and Richard, correct me if I'm wrong, is you're dealing with the situation where they put the felt on and then they're going to put ice and water shield on later, and what they're doing is they're deducting the area. The ice and water shield I think goes up 24 inches above the eaves. I'm not a contractor, but that's my recollection. And then they deduct the felt from that. The answer is they have a right to get it right. And if you're not going to put the felt in that area, their position is going to be, okay, if it's the ice and water shield and the felt's not going to go there, we're going to deduct for it. But you're also talking about the insurance industry on these roofing claims getting away with material minimums, getting away with labor minimums. It's really sad. They're really going after this based on the volume that they have. They feel they can save a lot of money attacking this stuff. I've had them argue that they're not going to pay for a material minimum. So if they're going to pay me for 10 feet of gutter, they're going to pay me for 10 feet of gutter, even if I can't go buy 10 feet of gutter. Now, we all know that's wrong, but that's what they're going to do. Okay, Jared, see this all the time. This is a great question. What do you do when an adjuster says that the code is not enforced? And the truth is there's no law on this. It's not like there's a written rule that says we have code coverage and it's the right way to do it and here's the code. But then if it's not enforced, they don't have to pay for it because you're not going to have to do it. My position is very simple. If it's required by code, by the building code, there's a reason why it's required by the building code. It's the right way to do it. And if my policyholder incurs that cost, the insurance company owes it. The bigger question that you should ask is the code enforcement is, why aren't you enforcing this code? And then ask them to put it in writing that they're not going to enforce the code. They will not do that. And if they don't do that, then you're fine. Let's see. I agree. Yeah, Levi. Yep. Estoppel. Ooh. Okay, Richard, do you want to be a little more specific, or did I miss something on here? I know you're talking about estoppel by coverage, where they maybe waiver an estoppel. Is that what you're referring to, Richard? Oh, I got it. You're talking about the felt, estoppel for the felt. Okay. If they paid the money and then they deduct it, but they pay you for the additional charge of the ice and water shield because that's going to be more expensive than the felt, that's different than if it was the other way around. You see, if the felt was more expensive than the ice and water shield, and they paid your insured that money, the policyholder gets that money, there would be a better argument that they're stopped from trying to get that money back. Okay? But at the end of the day, the felt is less expensive for that square footage than the ice and water shield. So they're still paying you more money. They're not taking any money away that's owed. They're just adjusting it. So that wouldn't be a great argument that they're stopped from not paying the felt, because you're referring to what's in the scope, right? Richard, you're saying, look, it's in the scope. If it's in this scope, you can't take it out of the scope. And unfortunately, it's not the way it works. What they call that is the reconciliation process, and there's not a judge that I'm aware of that I've argued in front of that's going to say, well, just because it's in a scope, if it's wrong and they're not taking money back away from the insured, what's your damages? Well, nothing, because you have to have damages. Now, it's an interesting issue is if you charge your client for that amount of money because you've already incurred that cost, right? That would be a different situation if your policyholder came out of pocket. But we all know, typically, the order of processes is you're collecting that money from the insurance company, not from the insured, other than the deductible. Yeah, Jeff, we don't owe for code because it's not enforced. Tell them you want that in writing. Tell them as a licensed contractor, or even in a jurisdiction that doesn't require a license, you are warranting that roof to that policyholder. You want that in writing, okay? That they're not going to enforce that code. And if they can't get it in writing, put the burden on the insurance company. Document what they said to you, okay? I always call it a tennis match. You always want to be ready to hit the ball back over. So if you're out there on the field and they say we're not paying it because it's not enforced, you immediately follow it up in writing. Thank you for your time today. Thank you for your inspection. It's my understanding, based on your representations, that X insurance company is not going to pay for items that we feel are required by code. Okay, and if you could cite to the code provision, it's even better. Based on your position that this code requirement will not be enforced by this municipality. Okay? If that is the case, please provide the policyholder such in writing. Okay, and that way you've done your job. If they can't give it to you in writing, you need to comply with the building code, and the insurance company should pay you for that. Now, if they can get it in writing, that's a different situation, but I've never seen it in writing. I've never seen a code enforcement agency put something in writing and they're not going to comply with the building code. Derek, how you doing? He has a question. Let's see. If you have an assignment of claims attached to your contract that the policyholder signed, can you present that to the insurance and it be legally binding without having a lawyer present to them? Wow, that's a great question. In most jurisdictions, yes. The biggest jurisdiction that assignment of claims is not permitted is Texas, guys. Okay? There's 3 or 4 states that an assignment of insurance claim is not valid. Texas is the one that I practice in the most that it's not. But in a jurisdiction that identifies the validity of an assignment of claim, yeah, it's binding. The insurance companies fight it, even with established law. I'm in jurisdictions that I've got Supreme Court decisions, and they're still fighting it, or they won't recognize it appropriately. And the remedies are very limited because you still have to have damages. So your remedy would be if the insurance company pays your homeowner or business owner and you don't get paid, you would have an action against the insurance company and the policyholder. That is not something that I would represent anybody on. I'm not in the business of bringing actions against policyholders at the Merlin Law Group. We're in the business of representing policyholders. But in your situation, if you have a assignment of claim that's valid and a jurisdiction that identifies them as valid, yeah, it's valid as soon as you submit it. Okay, Chris, can an insurance company depreciate labor and overhead and profit in the state of Illinois, and is it illegal to do so? It's a good question, Chris. What I'm going to do is ask that you email me that question, and I will give you the answer within 7 days. That one I know. I just got to get the right resources in front of me. I'm sorry. I have a chart. I keep a chart so that, because it's all different. I hope you guys understand that when you practice, I know some of you guys do what I do, especially public adjusters and some of those contractors that travel after catastrophes. Every jurisdiction is different. So I always like to have those charts in front of me when I answer those questions. So Chris, if you'll email me that, I'll make sure we get that answered. Robert, you hit on a good issue. He's talking about a mod bit roof that then had a different roofing system installed. I've represented contractors and policyholders that will take a existing roofing system and then put a different roofing system on. In fact, some insurance companies incentivize the insureds to do that. They incentivize them to do a different type of roofing system. For example, if you have a wood shake roofing system, a lot of insurance companies will incentivize their insureds through a deductible reimbursement program. That's right. The insurance companies will reimburse the insured the deductible to put a different type of roofing system on, like a composition roofing system. Okay? And it's often with wood shake. And so the question becomes what's owed under the policy, and the answer is what was there, okay, on the ACV basis. So there's a two-step process to this, Robert. You have an ACV basis and you have an RCV basis. The ACV basis is what's owed for what's there, right? So if you had a mod bit roofing system, they would owe you on an ACV basis of what's there. Then on an RCV basis, if you look at the loss settlement provisions, it's not that they have to actually pay you what the RCV amount is, or to the client, the policyholder. They owe the policyholder whatever's least, right? Whatever the least amount is as to what was incurred by the policyholder or what was estimated, right? So Robert, stay with me and let me give you an example. You've got I'll use your example, a mod bit. Well, let me use one that I know is a little bit different that I've actually had experience with, if you don't mind. Let's say you have a wood shake roofing system. On an ACV basis, they have to pay you for the wood shake system. Then on an RCV basis, they're going to have to pay you whatever the least amount is for what was actually incurred by the insured. So if it actually cost less than the RCV estimate for the wood shake system to put the composition system on, then that's what they would owe the insured. If it cost more, they're only still going to pay whatever the least amount is. So if it was less what was incurred, they're going to pay that. If it's less than what was estimated, they're going to pay that. Okay, John, labor cost in Texas was up 30 to 40% this year, but insurance pricing stayed the same. How do you combat that? Xactimate. Xactimate does extensive research. You should call them if there's a problem like this and bring it to their attention. Xactimate is something that's adopted by the insurance industry, but I've had very good experience with them when I reach these issues where they will adjust the pricing to match that. The other way to combat it is to provide 3 bids, okay? You got a job to do and Xactimate's wrong. Like commercial properties, Xactimate's not nearly as strong as it is on the daily claims or residential claims, okay? So what I do is instead of using Xactimate, I get 3 local bids. I get local contractors that are reputable, not my guys, not my forensic, whatever it is. It's people that actually do the job every single day, okay? And with my proof of loss package, I'll get 3 bids. If I've got a roof that's damaged, if I've got veneer that's damaged or siding that's damaged, like a general contractor would, I'd go get bids, okay? And I take those bids and I get multiple bids. And I usually take the middle bid as part of my demand package. And I take that middle bid and I submit it to the insurance company with all my bids, and my policyholder executes a proof of loss based on the middle bid. I'm reasonable, guys. That's being reasonable. No one's going to argue that's not a reasonable approach to determine what is owed for that job. So John, when you're dealing with something like that, you need, unfortunately, take an extra step, get those local contractors' bids to you, and submit them to the insurance company. That's how I combat that. And it works out well with me in front of a judge or jury when pricing is an issue. Levi, there's a lot of good public adjusters in Oklahoma. I know Kevin Burpee's licensed in Oklahoma. I know Dwayne with Kevin is licensed in Oklahoma. Oklahoma is a great jurisdiction. Needs a lot more policyholder advocates, Levi, because it's hard for me to find contractors that aren't in the pocket of the insurance companies all the time. It's very difficult. We have now got the resources to do it, but after practicing there for 4 years, it took us that long to find people that would give us objective opinions instead of subjective, biased opinions in favor of the carriers, because the carriers hired them all the time. So it was kind of a good old boy network there, but it took some time, but now we're getting fair results. Okay, we have a question from Mr. Armand. I'm never going to get this name right. How to overturn lowballing on shingle pricing based on current market pricing. Same thing. If Exactament's wrong, guys, get local bids. That's the best thing you can do. It works for me. Try it. If it doesn't work, let me know. Use the middle bid. Okay, Jack says Joe Ratcliffe uses something different in Texas of assignment of claim. Is it a direction to pay, Jack? Is that what he uses? A direction to pay, I think, is obviously still valid in every jurisdiction. Whether or not the carrier recognizes is a different story. Okay, Chris is asking for my email address. My email address is L, as in Larry. My last name Bache, B-A-C-H-E. It's L Bache at merlinlawgroup.com. I work with Chip Merlin's law firm. Been here for 7 years. Chris, sometimes I have an attorney on my team. I have 2 paralegals and an attorney on my team. Her name is Erin. Sometimes I take questions that I get sent, and I will forward them to her to research and provide me with a response, and I'll provide that to you. Just understand that sometimes you might see another attorney that's giving you a response because I may be in depositions or trial. I am a litigator, so I'm not always in the office. Okay, Richard, does code have to be enforceable? But the city doesn't send citing permits. Again, Richard, tell them to put it in writing. How can you as a contractor not comply with the building code without something in writing from that municipality? You just can't do it. So you got to tell the carrier, if that's fine. If they're not going to enforce it, I disagree, but I can't go do this job and then have code come in and red tag me. Okay, you can't do it. You're going to lose, and it loses for the policyholder. Thank you, Levi. I mean, guys, believe it or not, I promise you, Kevin and Jason, when these guys started this group, we saw a lot of people taking advantage of contractors and public adjusters trying to charge for advice to help policyholders. And we feel this is a good opportunity for us to help you guys, but I think we all agree that we're blessed to do what we do, but we also get to help the policyholders, as corny as that sounds. I know at least it means something to us. Yeah. Let's see. Oh, Robert, I see. They just got it wrong. Well, Robert, did they get it wrong the first time or the second time? You're asking about the mod bit question, Robert. Did they call it mod bit and it wasn't? Because that's a big fact. Okay, Lawrence has a great question here. How long after a data loss? Oh, okay. All right. Lawrence, there's statutes on this. Lawrence's question is, how long after a date of loss can an insured file a claim for storm damage in the state of Florida? Hail, windstorm, and hurricane. Okay, great question. You're about to get me on a soapbox. After Hurricane Wilma, there were a lot of claims that were not noticed until more than 2 years after the storm. Okay? So there was a lot of litigation over late notice claims. And it was great business for the defense bar as well as the plaintiff's bar, because notice is a question of fact. What does that mean for all my contractor and public adjuster friends? It means that summary judgment is very rarely granted for an insured's alleged late notice, okay? Which means that we get to go to a jury, and that's what we like to do. We want to have the opportunity to let a jury determine if the insured acted inappropriately or if the insurance company did, okay? So in Florida, after Hurricane Wilma, in 2010, we had a lot of litigation, and the defense bar and the carriers lobbied the legislature, and they passed a law. And Lawrence, this law is important to you. Last time I checked, it only applied to windstorm and hurricanes, okay? Did not include hail. But again, I'll verify that if you shoot me an email. And I believe it's 3 years. So they have a 3-year period of time to provide notice of a claim. Now, it's different than a statutory period of time to file a lawsuit, Lawrence. So this provided another date, not to be confused with a statute. Doesn't mean you can't file a lawsuit after 3 years on a windstorm claim, okay? It just means that if it's after 3 years, you've provided untimely notice of the claim, and the carrier is likely going to deny it. Any type of claim that has notice, any notice of a claim that has time that goes by, you have to rebut potential prejudice to the carrier's investigation. Engineers and those type of people can help you rebut that prejudice. Common sense, right? If it's a storm that requires 100-mile-per-hour winds to cause the damage, and the hurricane was a year and a half ago, and there hasn't been another storm that have 100-mile-per-hour winds, well, we can easily attribute that damage to the 100-mile-per-hour windstorm a year and a half ago. So that's significant in that situation. But those are the type of facts you look for. To the best of my knowledge, hail is not included in that 3-year period. But where you're going to have a hard time with hail is if you have multiple storms. Now in Florida, it's a little different. We don't have very large hailstorms very often. But if you're in a jurisdiction in the Midwest where you have hailstorms every April and May, and then every other November and October, or November and December, you're going to have a hard time if that notice was provided 2 years later or 3 years later, and you can't differentiate which storm it came from. Because it's your obligation to do that as a policyholder. The policyholder has an obligation to identify which policy has been affected. A lot of other issues go into that, guys. Is it the same insurance company that's been on the loss for 3 years in a row? Is it a different insurance company based on one date of loss versus another date of loss? It's hard to do this, answering these questions, because there's so many arguments that we make that we believe in. But in reality of it can be difficult. So the facts are important. The devil's in the details. Okay, Rob says, on your wood shake to comp example, does insurance owe for the redecking if claims still under the original scope? Well, Rob, was there more than 2 roofing systems on that deck already? The answer is obviously yes, if there is, because the code doesn't allow more than 2. If the deck's not damaged, but the deck can support it, if there's no damage to the deck, then no. I guess I have to get a little more clarification on that if I didn't answer your question. Okay, Chad says Exactaware price list in DFW stayed the same for about a month and a half after last year's major storms. After a ton of contractors emailed Exactaware, it went up by a lot in June. Amen, Chad, thank you. That's the same experience that I see. And guys, you should always update your estimates for the time of the repair. So you have an estimate for the time of loss, okay? But again, that's not enough time for that to be updated. Then what you do is you update your estimate and submit it as a supplement based on the price list at the time that you order your materials, at the time you coordinate the repair. That should be within 180 days, because the standard policy provides that you have 180 days to make your replacement cost benefits claim. What does that mean? Public adjusters know to do this. You should always notice to the insurance company that your client, if they want to, which I'd be shocked if they don't, because they're paying additional premium for the replacement cost coverage, if they're going to make a claim for the replacement benefits, you need to let them know right away. I often argue that a estimate that includes an RCV amount and an ACV amount is sufficient notice if better notice isn't given. I still maintain that position. That's your claim, claiming RCV benefits. But that being said, I add in all my letters for all my claims. Please take notice. Your insured intends to make the repairs to the property and make a claim for replacement costs once a dispute is resolved. Because oftentimes appraisal takes more than 180 days. Litigation may take more than 180 days. But the judges, that's a very plain term in the policy. They don't always fully understand the claims adjustment process, and we've gotten bad results. And maybe it's our fault for not explaining it better, but guys, we try. We explain it to them. We say it happens every single day. I take the deposition of the representatives and I ask them, if appraisal occurs and it takes more than 180 days, do you agree with me you pay the RCV benefits? They'll say yes. That's the important testimony to get. But sometimes it just doesn't happen that way in court, and they will hold that 180-day period as a strict term of the policy. Levi says ethical. Hope so. It's good. Good. Yep. Give Kevin a phone call if you have a question. Andy's setting a little bit of marketing up, appraisals. That is good. You guys should all work together. When you guys need help. There's nothing wrong with that. Guys, there's a lot of law and appraisal contracts, though. That's changed. You can't have a contingency contract in most jurisdictions. Be careful with that. Make sure you don't have a pre-existing relationship where that could be viewed as bias. It's okay if you work together, but if you go in business with somebody, you can't serve as that person's appraiser. Yes, Brooke asked a great question. Since you can't be a GC and a public adjuster in Oklahoma, is there any certifications or classes that would better knowledge would be worth obtaining? Okay. Brooke, if you're a public adjuster, the answer is absolutely. I recommend every single public adjuster to be, there's multiple facets of contracting and public adjusting in the insurance world. Number one is coverages. Okay, Brooke, you're a coverage expert. You're not day one. Okay, I wasn't day one. The best coverage expert I know is Chip Merlin. Okay, and I'm very fortunate to be able to go to him when I have questions and sit down with him. He's been doing this for a very long time. But the best thing for you to do is it's called an AIC, an Associate in Claims Designation. And all the claim managers, if they're worth anything, okay, all the VP of claims for the big guys, they get to put their little name, okay, Brooke, comma, AIC, Associate in Claims. And it's the best designation, in my opinion, that you can get to understand coverages. It's a very professional designation. I believe it's 4 major courses. We have the textbooks, obviously. You can go on Amazon. They used to be by Markham, M-A-R-K-H-A-M. Now, I think Markham sold those rights and it's with somebody else, but I haven't taken those books since it's changed. But I carry those books with me in my depositions, and I lay them on my desk, and I've got them highlighted, and I ask very simple questions out of those textbooks to the people that have those designations, and they have a hard time disagreeing with my position when I'm reading out of a textbook that they flaunt the designation for. Okay, and that's really claims handling issues. How's a claim supposed to be handled? You'll learn calculations, you'll learn about co-insurance and all that kind of stuff, but it's a great course. The second part of the public adjuster's role is damages. And if you're not efficient in Xactimate or SimSol, I would go with Xactimate. It's a software program accepted by more carriers, that's used by more carriers. Whether you agree with it or not is not the point. The point is you ask knowledge base. I've taken the Xactimate courses. I even took Sketch. I'm probably one of the few lawyers that took the time to learn how to sketch because I wanted to understand the process, and you should too. It'll make you better. and it's the best way to go. Brooke, we actually have a group of public adjusters in Oklahoma that are not affiliated with one another, but that we do quarterly meetings with just to help with the issues at hand. If you email me your contact information, I'll invite you to that group. Again, there's no charge. There's nothing like that at all. It's not about that, whether you believe me or not, but that's the best type of courses you can take. Okay, Nathan said it's no longer when you file claim, but when storm struck. That's correct. So it's, okay, so maybe earlier, I think I said date of loss, Nathan, but if I didn't, I'm sorry. It is the date of loss, Lawrence. So Lawrence, this goes back to your question. Thank you, Nathan, about the statute, the 3-year issue with the windstorm. That's the date of loss. So it's not when the carrier, it's not when your client noticed the damage. Chris asked, as a PA, I'm entitled to have my name on the check. Do they have to send it to my office? No, they don't. They don't have to send it to your office. There's no requirement that they do that. They have to have your name on the check. They don't have to send it to your office. Jared, space decking. My understanding is that's not really allowed anymore under the code, but I'll leave that to the contractors. My understanding is you have to have more of you can't have the, 1x8s, or I forget what that change is, but that's my understanding. The split decks. Under a PA contract, if the adjuster calls the insured to get info to try to deny the claim, is this constant reason for complaint to Department of Insurance? Yeah, I mean, if they didn't go through you, right? You're never going to refuse access to the insured, right, Chris? You're never going to refuse to cooperate and participate in a claim investigation, but you are designated as the representative of the insured. As a result, they are supposed to go through you for contact. You should always discuss with your clients that the insurance company is not to contact them directly, and if they do, they should immediately ask them very politely to call their public adjuster and that they are willing to fully cooperate. Okay? Okay, Gus, thank you for the website. That's great. Jared, Ameriprise refuses to update price list. What can you do? Take their butt to appraisal. That's a dispute over the amount of loss. It's going to cost a little money out of pocket for you depending on the amount of loss, but once you do it once or twice, they should stop messing with you. Chad, great job. See, Chad, you're working it. You got the people at Xactimate. Get it? There you go. Thank you, Jared. You got to install sheathing over it. That's what I thought. Okay. All right, guys, is there any more questions, or how long have we been going on here? This has been great. About an hour and 20 minutes. Chris, thank you guys. Let me know if you guys like this. Was this beneficial for everybody? I thought it was pretty engaging. I think it's great, but I want to make sure it's beneficial. And if you guys have any questions, just let Kevin and I know. You can post them on the group page. Great. Thanks, guys. Okay. You guys think we should do this once a month? Is that sufficient? Because I know that IMG is going to be hosting presentations at least once a month. My only concern is that I'm not going to be able to make it on February 2nd. I have a position in Missouri, so I'm sorry I'll be missing some of you there. Great. Okay. Thank you, everybody. I'm going to go ahead and sign off. Please follow up with those emails. I'll get those answered. For state-specific questions on labor, I have a chart that I'm working on anyway. Thank you, everybody, for joining me today. I hope you guys will do it again. Once every 2 weeks, Jason, I think we could probably do that. It was nice seeing everybody. Ivan, thanks for joining. Thank you, Russ. Thank you. Once a week, William, I wish. Unfortunately, I don't think I could do this once a week, but maybe we can get other people to help out and do it too. Daily, yeah, Chet, I'm with you. Nathan's going to be snowboarding, yep. Right. Thanks, guys. I'm going to sign off now. Appreciate everybody joining, and wow, I can't believe how many people we had today. This is great. It's very exciting to help people and help the policyholders. Justin, real quick, I'll be speaking at the Merlin Law Group event in March. It's at Beaver Creek. I don't know the exact date, but I will have that. So thank you guys very much. You guys all have a good day, and I'll talk to you guys soon.